Hello everyone, my name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this video, we will be discussing the recent development which has happened in the area of polity in the past weeks. So let's start our discussion. Today we will be discussing 6-7 topics. So let's start without any further delay. Okay. So here we will be discussing accessibility for disabled is a fundamental right. Recently Supreme Court has declared that the accessibility for disabled is a fundamental right. It is a human right as well as a fundamental right now under Article 21 of the Indian Constitution. Okay, that is one thing we will be discussing, and after that we will be moving to the next part, that is minority status of Aligarh Muslim University. That particular status was in question in front of Supreme Court, and Supreme Court has devised a holistic test. Then we will be talking about the concept of minorities over here, that India has two kind of minorities. One is your religious minority and second is your linguistic minorities. Okay, so we will be talking about these two. Then in further moving, we will be seeing appointment of 51st Chief Justice of India, that is Sanjeev Khanna. So we will be talking about the appointment, we will be talking about the eligibility, we will be talking about the powers of CJI, and then we will also be talking about the power and jurisdiction of the Supreme Court. After that, Bulldozer justice and the Supreme Court stand. Recently, you know that there are various you can say incidents wherein the unauthorized construction has been demolished by the executive action, but there were allegations that they are targeting certain people. So that is why there was this issue of bulldozer justice which was raised in front of Supreme Court, and Supreme Court has given a verdict. Over there Supreme Court has also given certain direction with respect to the demolition. Okay, and the direction has been given under Article 142 of the Indian Constitution, wherein Supreme Court can go for giving any kind of direction for the complete justice delivery. Okay, then in the end we will be talking about the Armed Forces Special Power Act, that is AFSPA, which is an act from 1958. Okay, so we will be talking about this particular act because recently in Manipur it was reinforced. Okay, reinforced you can say, so that is why it was in news. Okay, so let's start our discussion. We will be starting first with the accessibility and then we will be moving forward. Before moving further, we have this announcement that GS Foundation course for prelims as well as mains in English medium at our offline center, that is Delhi, will be starting from 26th of November 6 p.m. So you can directly visit the center and get yourself enrolled, or you can call on this number, that is 8010440440. Okay, other than that, if you have not subscribed the channel, please subscribe it. So then moving further, we will be seeing the explanation of the questions which has been given to you in the previous lecture. So we have been giving you these questions in the previous videos, but we did not go for the explanation, but this time we will be starting to go for the explanations as well. Okay, so Right to Education Act mandates free and compulsory education for children aged 3 to 10 years, 6 to 14 years, 8 to 15 years and 10 to 16 years. So option B would be your right answer, that is 6 to 14 years. Okay, now moving to the second question, that is which amendment removed the right to property as a fundamental right, that is you can say 44th Amendment Act. Okay, so that is your answer here. Then moving further, the landmark case in which the Supreme Court of India declared the right to privacy as a fundamental right under Article 21 was Keshwanand Bharti versus State of Kerala, Indira Nehru Gandhi versus Raj Narayan, Puttaswamy versus Union of India, Minerva Mills versus Union of India. So option C is your right answer, that is Puttaswamy versus Union of India, which has declared right to privacy as a fundamental right under Article 21. Okay, Keshwanand Bharti is important case which you can remember that is related to the basic structure doctrine. Okay, so let's move further. So the question is, State Reorganization Day is primarily celebrated to commemorate the formation of states based on cultural factors, linguistic boundaries, economic potential and potential population size. Option B is your right answer over here, linguistic boundaries. Though one state, one language formula was not used over here, but still it was, the reorganization was based on the linguistic phenomena. Okay, so I hope these questions are clear. Now let's start with the AFSPA. Accessibility. AFSPA we will be discussing in the end. Okay, accessibility for the disabled person is a human and a fundamental right, says the Supreme Court. Supreme Court has taken the cognizance that if you are not able to provide services, or you can say you are not able to provide accessibility to the disabled person, then it is your fault. This is you can say a loophole, or you can say a void which has been created by or which is basically putting the question on the capacity of the state and not there. Okay, so basically here they have said that it is obligation on the state that you can say all the institutions, all the premises are made you can say properly inclusive and accessible. Okay, so that has been given, you can say verdict which has been given by Supreme Court, and Supreme Court here has said that accessibility for disabled person is a fundamental right under Article 21, that is basically right to a dignified life. Okay, so that is there. Now let's see what Supreme Court has seen over here. Supreme Court said that accessibility for disabled person is a human and a fundamental right. Then they have gone for the universal design principle. Okay, that means that all the, you can say, when we are talking about the designing of all the premises, etc., they should follow one particular format. Okay, here directive to implement it in public and the private spaces. Spaces should be usable by all, irrespective of the age, ability and the status. That means that whenever you are going for the designing the space, it should be made in such a way that it is accessible by all the people, irrespective of the age, status or the ability. Okay, so that is basically your universal design principle. Supreme Court has said that you have to follow it in both private as well as the public spheres. This design principle promotes inclusivity, enabling disabled person to participate equally in the society. So this has been, you can say, this is the observation which has been given by the Supreme Court. Here we will be seeing that what are the challenges which are faced by the disabled person on the daily basis. Okay, so first is accessibility barrier. We have seen that there are various campus where you won't be finding ramps, where you will be having stairs but there are no ramps. In that case, if a person with a wheelchair is going inside the campus, then he won't be able to access all the part of the, you can say, campus. Okay, so here accessibility barriers are there. Only 3% of the buildings are fully accessible. That is one thing. Second is infrastructure deficiencies. Okay, inadequate facilities in public and public spaces and the transportation. When we talk about the buses, etc., you will be seeing that buses has the footrest or steps through which you are getting inside the bus, but they are not having ramps, so that you can say people with a wheelchair can get inside the bus. So that accessibility is not there with respect to the public transport. Okay, so that is the second thing. Other than that, also infrastructure deficiencies are there in when you look at the various spaces around you. So if you talk about schools, if you talk about hospitals, if you talk about bus stands, you will not be getting it over there. Okay, so as I told you that only 3% of the buildings are fully accessible. Then coming to the next one, that is educational exclusion. When we talk about the, you can say, number of people, or you can say percentage of people who are illiterate in this particular category, when we talk about the disabled person, 45% of disabled people in the age of 3 to 35 years, these are basically illiterate. So we can say that there is a educational exclusion which is there, because buildings are not accessible, they are not able to go there. Okay, other than that, workplace discrimination, you will be seeing that when we talk about the discrimination which is happening over there, so there are various stigma which are been attached over here. So you will be seeing in, you can say, in the workplace also there is a discrimination. Then employment gaps. If we talk about the education, if there is a education exclusion, that means that will reflect in the employment gap as well. Okay, so out of 30 million disabled person in India, 13 million are employable. Okay, out of 30 million, 13 million are employable, and out of 13 million which are employable, only 3.4 million are actually employed. So we can say that out of 30 million, only 3.4 million are employable, nearly you can say 10 or 11%. Okay, so that is the data which is talking about the exclusions which are faced, or the challenges which are faced by the disabled person on regular basis in daily life. Now coming to the next one, that is talking about the Supreme Court's decisions. So what Supreme Court has done over here is that human and a fundamental right. Accessibility has been made a human as well as a fundamental right. The right of person with the disability to access services and opportunity. This right is not effectively implemented at the ground level. Okay, that has been the observation of the Supreme Court, that they have seen that it is not been implemented on the ground level, and that is why it was made a fundamental right. Okay, making it a fundamental right makes it enforceable on its own. Okay. Then coming to the next one, Chief Justice view over here. Disability becomes a tragedy when society fails to provide necessary facilities. Now the thing is, if there is a person who has this issue with the accessibility to a campus. Now if campus is made inclusive, if the, you can say, facilities are there so that a person can access all the services which are provided in the campus, that means that there is no disability at all. Okay. Now the thing is that particular tragedy is there because society is not able to provide the necessary infrastructure to them. Okay, so it is not basically incapacity of those people, it is the incapacity of society which is basically here in the question. Okay, so disability becomes a tragedy when society fails to provide the necessary facilities. For example, if a metro and bus services in the city are not accessible to people with disability, it reflects the failure of that particular society. Okay, I hope that is clear. Now moving further, here it is also said that emotional and the relational challenges which they are facing, on which also Supreme Court has said something. Society overlooks the right of persons with disability to privacy and love in their personal lives. They are not given private spaces, their emotional rights are not actually given importance. Okay, so that has been made, and that is one observation which the Supreme Court has seen. Mandatory disability regulations. Now there is this act, that is Right of Person with Disability Act. Okay, in that you can say these regulations and the right, these are not basically kept mandatory, and that is why court has said that within certain time, within 3 months of time which has been given to the government, and court has said that you have to make it mandatory, you have to implement mandatory regulatory provisions which are there in this particular act, that is Right of Person with Disability. Okay, now other than that, they have talked about the importance of accessibility, which we have already seen that essential requirement, accessibility enables individual, especially disabled person, to exercise their right. Example, lack of wheelchair ramps impact the independence and the dignity of a workplace. If there is a workplace and if there is no ramp which is there, that means that that person cannot take a job in that particular place. So that is how it is impacting their employment, their education status, etc. Okay, so here it is being given importance that accessibility is a essential requirement. Okay, then social mode of disability, the court highlighted that disability arises due to the external barriers and not personal limitations. Now that this is not a person's fault, or this is not on the onus is not on that particular person, onus is on the society to make sure that that particular person do not face any kind of discrimination. So you have to provide services to that particular person, you have to make sure that every infrastructure you create is inclusive and accessible to disabled people. Okay, now example, inaccessibility or inaccessible public spaces due to the lack of the braille signs and the audio guides, this is a failure of the society. Okay, so ultimately in this particular judgment, only two things which are important for you to understand: that one, that accessibility for a disabled person has been made a fundamental right under Article 21. Second, it is a fault or it is an incapacity of society and not the person if we are not able to provide accessible and the inclusive infrastructure to them. Okay, so these are the two broad factors which has been discussed in this particular judgment. Now we can move further with the next one. Minority status of Aligarh Muslim University. Now you know that this is a very important and you can say education institution which is there in India, and there has been question with respect to the status or the category of this particular institution, which has been asked in the court various times, in the Allahabad High Court and then in front of Supreme Court. So we will be seeing that what was the issue. We will be looking at the history of this institution as well. So here you can see 1877, Sir Syed Ahmad Khan established the Mohammedan Anglo-Oriental College for upliftment of the Muslims. So he was a social reformer. Okay, Sir Syed Ahmad Khan, you must have heard about him in the modern history. Okay, so he has established Mohammedan Anglo-Oriental College for the upliftment of Muslims. Okay, now that is the time, and after that in 1920, British Act was there, that was the AMU Act. With that particular act, it becomes Aligarh Muslim University. Okay, earlier it was the Mohammedan Anglo-Oriental College, which has been converted into Aligarh Muslim University through an act, that is AMU Act. Okay, then moving further, in 1950, when we have got the transfer of the power in our hands, so in 1950 Parliament declared AMU as an institution of national importance. So that was you can say one step which they have taken in further. Then in 1951, AMU Act is amended, allowing non-Muslim to be the member of the AMU Court. Now AMU Court is basically the body which is responsible for the governance of the institution. Okay, or you can say administration of the institution which was there. Earlier only Muslims could be the part of that particular body, and with 1951 Act, non-Muslims were also included in this body, that is AMU Court. Okay, after that in 1965, another amendment expands the power of AMU's Executive Council. Now AMU court is there, executive council is there. Now AMU's executive council, which has been given more power, university court is no longer the supreme governing body. Okay, so university court, that is AMU court, was not now a supreme body. Now there is AMU's executive council. Now in 1967, Supreme Court on challenge to the amendments says AMU cannot be classified as a minority institution. Aziz Basha case was there. So in that case, Supreme Court has said that AMU cannot be classified as a minority institution. Okay, what was the basis? We will not go into details of that, but just know that in the executive council over here, non-Muslims were also there. Okay, other than that, it was also a institution of national importance, and that is why Supreme Court said that it is not a minority institution. Okay, so Supreme Court rules on the challenges to the amendments says AMU cannot be classified as the minority institution. That is there in the Aziz Basha case, 1967. After that, 1981, Indira Gandhi's government amends the AMU Act, declaring AMU was established for the education and the cultural advancement of the Muslims. Okay, so it was trying to, this particular act was trying to give a minority color or the minority institution color to the AMU. Then in 2005, an AMU introduced 50% reservation for Muslims students in the postgraduate courses. In the postgraduate medical courses, they have introduced 50% reservation for the Muslims in 2005. In 2006, Allahabad High Court quashed the policy, and in 1981 amendment, the UPA government and the AMU moved to the Supreme Court for the verdict. Okay, now in 2006, they have actually quashed these two decision which has been there, or the act and the, you can say, policy decision which was taken in 2005. These two were quashed by the Allahabad High Court. Then matter goes to the Supreme Court. Okay, now this is the 2006 when matter goes to the Supreme Court, wherein they have quashed these two and they have challenged that particular decision of Allahabad High Court. In 2016, when the government changes, so the government has actually said that since that decision was taken by the UPA government and that was not a rational decision, we are taking withdrawing from the suit. Okay, so here you can say the central government withdraws from the appeal, saying UPA government's stand was against the public policy of the reservation SC, ST, OBC, EWS as applicable to the central universities. So basically here 2016, the central government has withdrawn from the case. But in 2019, the court, the 3-judge Supreme Court bench refers the issue to the 7-judge bench. Okay, now 7-judge bench has given a decision over here. So it is clear that earlier it was a institution of national importance, and then in 1967 Supreme Court said that it is not a minority institution. Then there was this act which has given a color that it is you can say a minority institution, and they have gone for the reservation policy also. These two were challenged in the court, and Allahabad High Court has struck them down. Then the matter comes to the Supreme Court, and in Supreme Court the government says that we are withdrawing the case because this was against the public policy, and in 2019 that was referred to a higher bench, and now we come to the next, that is basically the decision right now. Okay, so let's see what is the issue. Minority status, whether AMU can be classified as a minority institution and therefore be allowed special protection under the Article 30. Okay, Article 30 in the Constitution we will be talking about, that is basically talking about the minority institutions. Now judgment, the Supreme Court's new test for the minority character includes evaluating the institution's mission. There are 3 things the Supreme Court has talked about. One thing is that you have to look at the institution's mission, one thing. Second thing is the socio-political climate, that is the second thing. And third is how effectively the institution serves the community without discrimination, that how well community is providing services. So I mean the institution is providing services to the community without any discrimination. Okay, so these 3 things were there, which Supreme Court has said that you have to look at these 3 things. Okay, rather than just the intention of the founders. We will not solely rely on the intention of the founder. Intention of the founder here was upliftment of the Muslims. Okay, now holistic and the realistic test intends to clarify AMU's status could influence the similar you can say cases in the future as well. Okay, so this was basically, you can see, the crux of the case, wherein they have come up with the test wherein they have to look at these 3 features before deciding the nature of a institution. Okay, now coming to the next part over here, concept of minorities. In India, we use this term minority in the Constitution, but the Constitution does not define it. Okay, but there are 2 articles which are related to it, Article 29 and 30, which is talking about it. So we will be talking about that as well. Okay, so the Constitution of India uses the word minority but does not define it. Please remember that Constitution of India does not define the word minority. Okay, Article 29 uses the word minority in its marginal heading, but speaks about this particular quotes which are given or which are taken from the Constitution provision when we talk about the word which has been used in the heading, okay, not in the section. So any section of the citizen inhabiting the territory of the India or any part of the country should have the right to protect their language, script, culture, which is different and varied. So basically it is protection which has been given to the language, script and the culture to any section of the citizens, okay, any section of the citizens. So that is there. And it also says that the citizens should be allowed to take admission in any educational institution which is maintained by the state or getting help from the state's fund, whether vary in religion, race, caste, language and any of them. So if there is a person who wants an admission to an institution which might be having a different character, or most of the majority over there is from a particular community, but if it is funded by state, okay, so that particular person, if whether it is of the same, he is of the same religion or not, he will be allowed to get admission in that particular institution. Okay, Article 30 of the Constitution of India talks only about the religious and the linguistic minorities. Now Article 29 here, that is saying that any section of the citizen, they are not talking specifically about the minorities, but Article 30 is specifically talking about the religious as well as the linguistic minorities. Okay, so let's see. It ensures the preservation of minority rights. Article 30 of the Indian Constitution states the right of minorities to establish and administer education institution. Okay, so right of minorities to establish and administer the education institution. Okay, so here it is clear that they are talking about minorities. In Article 29 they are talking about any section, that means that including minorities, any other section can also be going for the, you can say, preservation of their language, script, etc. Okay, Article 30 clause 1 says that all minority, whether based on religion or language, shall have the right to establish and administer education institution of their own choice. Okay, so basically it is made clear that there are two kind of minorities which has been discussed in the Constitution. One is your linguistic, second is your religious. Okay, now coming to the other provision, which is basically your Article 30 clause 1a, which was added later. So here you can see it deals with the fixation of the amount for the acquisition of property of any educational institution established by the minority group. Now if you are about to take a property of a educational institution, then you have to go for give the compensation, and for that provision has been made in Article 31a. There is a fixation of the amount for the acquisition of the property of any educational institution established by the minority group. Again, it is only for the minority group. Now minority group, if they have a particular place that educational institution is there and they have a land around that, so if the government is taking that particular land, in that case there is a fixed amount that government has to pay for that. Okay, then Article 30 clause 2 states that the government should not discriminate against any educational institution on the ground that it is under the management of minority, whether based on religion or language, while giving aid. That means that when government is giving aid to an institution, then they should not discriminate on the basis of the fact that the management of that particular institution is with the minority. Okay, so these are certain protections which has been given to the minority institution under Article 30. Okay, now coming to the two kind of minorities. In India we are having two minorities. One is your religious minority. The basic ground for the community to be nominated as the religious minority is basically population, numerical strength of the community. Okay, Section 2 clause C of the National Commission for Minorities Act declares 6 minorities as minority communities. In India we have Muslims, Christians, Buddhists, Sikhs, Jains and Zoroastrians, that is Parsis. Okay, so in states these minorities can vary, but at the central level we have 6 minorities: Muslims, Christians, Buddhists, Sikh, Jain and Parsis. Okay, so these are your religious minorities. Then linguistic minorities, class or group of people whose mother language or the mother tongue is different from that of the majority group is known as the linguistic minority. That means that if their language is different from the majority of the group, that is linguistic minority. Article 350A imposes an obligation on the state to try to provide enough facilities for instruction in the mother tongue at the primary level. Okay, what they are saying, that try to provide enough facilities for the instruction in the mother tongue at the primary level of the education to the children belonging to the minorities, linguistic minorities. Okay, so basically that is given under Article 350A, which is giving an this is putting an obligation on the state that they have to provide facilities so that you can say instruction to the children can be given in the mother tongue for the linguistic minorities. Okay, so this is about minorities. We have talked about the Aligarh Muslim University. What was the issue? We have seen that what test has been designed by the Supreme Court in that particular case. What was the history? We have also mentioned Sir Syed Ahmed Khan over here. We have also seen that there are different kind of minorities which are there, which has been talked in Article 29 and 30 of the Constitution. And then we have seen that in the act which is there, that is the National Commission of Minorities Act, there are 6 religious minorities in India which has been actually selected. And when we talk about the religious linguistic minorities, we have Article 350A, which is saying that you can say instructions should be given in the mother tongue at the primary level to the children which are belonging to the linguistic minority. Okay, I hope that is clear. Now we can move further to the next one, that is basically talking about the power and jurisdiction of Supreme Court, along with Justice Sanjeev Khanna as 51st Chief Justice of India. The outgoing Chief Justice was D.Y. Chandrachud, and he is the new CJI, that is Sanjeev Khanna. Now here we will be talking about the eligibility criteria, we will be talking about the appointment, we will be talking about the role of CJI, and then we will be moving to the powers and the functions of the Supreme Court. Okay, so first, qualification. First is should be the citizen of India. Second thing is he should have been a judge. That means that there should be an experience. He should have been the judge of High Court for 5 years, or he should have been advocate of High Court for 10 years. Okay, so that is there. Judge of a High Court or High Courts in the succession for 5 years, or an advocate of a High Court or High Courts in succession for 10 years, or distinguished jurist in the opinion of the president. Now this is something which is there, that if there is a person who is not a judge or the lawyer, but he is a distinguished jurist in the eyes of president, then he can also become the Chief Justice of India. Okay, so these are the qualifications which are there. Now there is no minimum age which has been prescribed over here, but retirement age is 65 years. Okay, no minimum age for a person to be the judge of Supreme Court, but retirement age is basically your 65 years. Okay, now appointment, who will do the appointment? Appointment will be done by the president. Now the name of that particular person from the Supreme Court will be given. Most of the time it is seen that the most senior most judge of the Supreme Court will be nominated for the role of the CJI, but the thing is there are exceptions which has been in the past. So please note that this is not a, you can say, rule, it is a convention. Okay, so the name will be given from the collegium, that will go to the law ministry. Law ministry will send it to the PM's office, that is basically your council of ministers, you can say, and then that will be given to the president. Now you know that president works on the aid and advice of the council of ministers, and president now then they can go for the appointment of a CJI. Okay, so here CJI is appointed by the president under Article 124 clause 2 of the Indian Constitution. As per the protocol, the senior most judge of the Supreme Court is designated as CJI. The recommendation of the senior most judge of the Supreme Court is officially communicated by the incumbent CJI to the Ministry of Law and Justice, which then relies on the communication to the Prime Minister. The Prime Minister advises the President on the recommendation, and then the President is appointing the Chief Justice of India, which we have already seen. Okay, now coming to the next one, what is the role of Chief Justice? Now President, when we talk about the swearing in ceremony of the President, who will administer the oath of President, that is basically your CJI. Okay, so that is one thing. Second thing is he is the master of the roster. That means that who will cater to which case, which judge will get what case, that will be decided by the CJI. So that is their master of the roster. Okay, then CJI along with the collegium for the Supreme Court and High Court. So basically for the appointment and transfer of the judges, for that we have collegium, in which CJI and 4 senior most judges will be there. So there also he will play an important part. Okay, then CJI appoints the ad hoc Supreme Court judges under Article 127 of the Constitution. With the proper approval of the President, CJI can change the seat of the Supreme Court as well. Okay, right now we have the seat of Supreme Court that is there in Delhi. If CJI wants, with the approval of the you can say President, he can change the seat of the Supreme Court as well. Okay, CJI can appoint an arbitrator to resolve the financial dispute between the center and the state. These are the roles of CJI. And we have talked about the eligibility, we have talked about the, you can say, appointment. Now we will be talking about the, next part, that is basically your powers and jurisdiction of the Supreme Court. Now we know that jurisdiction, when we talk about, so there are two kind of jurisdiction which Supreme Court has. One is original, then appellate is there. So when we talk about the original jurisdiction, so center versus state, if there is a case between center and the state, or if there is a dispute between center and the states, that it will directly be under the jurisdiction of the Supreme Court. Okay, then center versus multiple states, that will also be under the, you can say, jurisdiction of Supreme Court. Then state versus states. Okay, now in these category, one category can be there that one side center and few states will be there, and other side other states will be there. So that categories are basically, if we talk about the all permutation and combination with respect to the disputes between states and the center, that is the original jurisdiction of the Supreme Court. Okay, now coming to the next one, that is basically writ jurisdiction, that is also there. So basically there are three jurisdictions. One is your original, appellant, and the writ jurisdiction which is there. Other than that also there are certain power. So here first is your habeas corpus, that ensure the protection against the unlawful detention. If someone is detained without any kind of warrant or unlawfully, then you can directly go for the habeas corpus, wherein Supreme Court or the, you can say, even High Court can give the direction to the, you can say, executive, that you have to produce the body within this much hour. Okay, then mandamus. If there is a public authority, they are not performing their duty, in that case you can directly go to the Supreme Court. If there is a, you can say, fundamental rights has been violated, okay, in that case you can directly go to the Supreme Court, and Supreme Court can issue a writ directing that particular executive body to go and fulfill their duties. Okay, so that is there, commands the public authorities to perform the duties. Then prohibition, with the name it is clear that they will prohibit, so prevent the lower courts from the exceeding their jurisdiction, to make sure that they are working in their own jurisdiction and the powers. So that is there, which is basically prohibition, that is with respect to the lower courts. Okay, here you will be seeing that that is against the executive action, that is against the, you can say, public authorities. Okay, this is against the lower courts. Now quo warranto, questions the authority of the public officials. If there is a, you can say, act which has been done by the public officials, Supreme Court can ask, or the court can ask, that with what authority you have done that. That is basically your quo warranto. Okay, then certiorari, that is review decision of the lower court. So there is prohibition and certiorari which are there with respect to the lower courts. So here in the certiorari they will be reviewing the decisions of the lower court. Okay, so that is the power and jurisdiction of the Supreme Court with respect to the original and the writ jurisdiction. Now talking about the appellate jurisdiction. So there are, constitutional matters wherein you can say High Court can decide on that, and then Supreme Court can also decide on these particular issues. The Supreme Court's role in interpreting and upholding the Constitution. Now Supreme Court is the final interpreter of the Constitution, which is a established, you can say, case. Now civil matters, jurisdiction over the disputes between the individual and the organization. So in the civil matters also there is this appellate jurisdiction. Then whatever you can say decision has been given by the High Court, then that can be challenged in the Supreme Court. Okay, then criminal matters. Now authority to hear appeals in the criminal matters as well. Okay, there are certain, you can say, restrictions or the certain conditions which are there that has to be fulfilled, but there is a criminal matters which can be challenged in the Supreme Court if the person is not satisfied with the High Court's order. Okay, then special leave appeals. There are certain areas where Supreme Court is not the first authority to decide, like when we talk about the river disputes, etc. So there is this river board which are there, which are to be created for that particular issue. So Supreme Court does not have authority over there, but with the lieu of the special leave appeals, they can actually allow. Okay, so there is this special leave which is their discretion to hear the cases not typically within its jurisdiction. If there is a case which is not within the jurisdiction of the Supreme Court, but Supreme Court wants to hear it, then with the special leave they can go for it. Okay, so that is about your, you can say, appellate jurisdiction. Other than that, here Supreme Court's advisory role. Supreme Court can give advice to President over here on the two matters. One is your pre-constitutional treaty dispute, okay, and public importance question. Now when we talk about the pre-constitutional treaty dispute, here you can say Supreme Court has to give the advice. Okay, so Supreme Court does not have the you can say opportunity to say no to such cases, but in this case, public important question, Supreme Court can deny that they do not want to give the advice on that particular matter. Okay, so that is the Supreme Court's advisory roles. Now Supreme Court as a court of record. Okay, article 129 of the Constitution, that is talking about Supreme Court, and it is saying that Supreme Court is a court of record and it has power to punish for the contempt. Okay, so contempt power, authorized to punish for the contempt if someone is going against the order of the Supreme Court, or if they are making a derogatory remark on the Supreme Court, then Supreme Court can take action over here. Then coming to the permanent record, it is a room of permanent record, or you can say that it is a court of record. That means that whatever decision has been taken by the Supreme Court, that can be used as a precedent in the other courts, or you can say that can be used as a reference in the other courts. Okay, so records that serve as a legal evidence and the precedent in the courts. So this is about your you can say Supreme Court as a court of record. Then judicial review power, which is given under Article 32, which is quite important when we are talking about the UPSC examination as well. So ensuring constitutional compliance, that means that if a law which is there, that law has to be compliant with the Constitution, and if it is not, then it can be challenged in the Supreme Court, and Supreme Court can decide whether it is aligned with on the lines with the Constitution or not, and if it is not, they can declare it null and void. Okay, so basically executive action and the legislative action, these can be challenged in the Supreme Court, and Supreme Court can decide whether they are in line with the Constitution or not. Okay, so these are the powers of Supreme Court which we have discussed. We have discussed the eligibility, we have discussed the appointment, we have discussed the role of CJI, and then we have discussed the power and jurisdiction of the Supreme Court. Now we can move further to the next one. Okay, bulldozer justice and the Supreme Court's stand. Okay, now Supreme Court, in this particular case, there are various incidents which has happened with respect to the bulldozer justice, that there are various accused person whose properties which might have some kind of illegal construction that has been directly demolished by the executive action, then proper procedure was not followed over here. So that is why there were various petitions in the Supreme Court, and Supreme Court has taken a stand on that, and Supreme Court has mentioned certain things over here. So Supreme Court has said that it is the violation of the right of who is the right of the accused person over here. Demolition without the due legal process is deemed as unconstitutional because it is against the right of a person. There are principle of natural justice which has to be followed. Okay, that means that a person should be given a fair you can say chance for the fair hearing. Okay, and if you are not following their due course, or if you are not following the due procedure, that means that you are working against the law. Okay, so that is one thing, violation of right. Second thing is that right, you can say that is under Article 14. Okay, then rule of law, executive action that punishes individual outside the judicial process undermine the rule of law. Now we have rule of law, we have procedure established by law, we have due process of law which has to be followed. Okay, otherwise you are not following the rule of law, and India follows rule of law under Article 14, you know that. Okay, so that is why Supreme Court has said that if you are not following the procedure before the demolition, that means that you are undermining the rule of law. Then third is the separation of power. Now deciding what kind of punishment will be given to a particular person, that is a judicial function. Okay, and not executive function. So that is, you are violating the separation of power as well. Then natural justice, if we talk about, so such actions are against the natural justice principle, promoting a culture of arbitrariness. How it is against the natural justice? As I told you that under natural justice it is said that a person should be given a fair opportunity to present his own case as well. Okay, so these are certain things which Supreme Court has actually talked about. So I would want you to go and do some more research on these arenas over here, that is rule of law, procedure established by law, due course of law, separation of power, and principle of natural justice. Okay, now moving further, Supreme Court has given certain directions over here. Supreme Court has said that if you want to demolish unauthorized construction, then you have to give a show cause notice. First you have to give the notice, and then you will wait for the 15 days to get a response. Okay, affected individual must have at least 15 days to respond. Notice should be sent by the registered mail or posted on the property. Okay, then individual can appeal after the receiving the demolition notice. Once individual has received the notice, he has 15 days and he has right to appeal. Okay, if he thinks that this particular notice is wrong, then he can go for the appeal. If that particular person thinks that he has gone for the illegal construction, that notice is fair, in that case he should be given at least 15 days of time to, or you can say reasonable time, to make sure that he vacate the property. Okay, non-appealing individual should be given enough time to vacate. Okay, that time should be reasonable. Then affected individual have right to personal hearing. A person who is going for the appeal, he should be given a right to personal hearing. Once that hearing is done, then only court will give you a judgment. That will be the final demolition order. Okay, so final order must be clearly state the reason of the demolition, consider the alternative action as well. Okay, so this is the procedure which is there to get a final order of demolition. What happens after that? Once the order, you get the order, you have to wait for 15 days to execute the order. Okay, let's see, you have gotten found the order on 16th of August. Now you have to wait for 15 days. You cannot go on 17th of August and demolish the property. You have to wait for 15 days because there is a chance that particular person might go for the appeal. Okay, so 15 days before enforcement you have to wait, and then that person can go for the appeal, and the order should be placed on the digital portal for the public access. Okay, so that is also there. Demolish the unauthorized structure only. Once you have gone for the appeal, etc., and your order is upheld, then you can go for the demolition of the particular structure, only the unauthorized structure and not the whole structure. Okay, that is there. Now when you are doing the demolition, then you have to make an inspection report, you have to make a videography of that particular you can say incident which has happened over here, and along with that there is an official accountability that only the unauthorized construction is demolished. So that has been given by these are the directions which has been given by the Supreme Court over here. Okay, now let's move further to the next one, that is your AFSPA. Okay, so Armed Forces Special Power Act. As I told you that situation in Manipur is not very good, and Manipur recently government, or you can say Ministry of Home Affairs, has imposed or reimposed AFSPA in the Manipur. Okay, Manipur's problem is basically your ethnic violence which is going on over here. That is the issue which has started from the developmental disparity, and that has taken the color of the ethnic violence over here. Okay, now let's see how AFSPA works and what is the background of AFSPA. Okay, a reincarnation of the British era legislation that was enacted to suppress the protest during the Quit India movement. Okay, during the Quit India movement, they have come up with the act which was having which was on the similar lines with the AFSPA. Okay, the AFSPA was issued by way of 4 ordinance in 1947. In 1947 as well, the you can say the situations were not very good. We were a nascent state, so we have retained the law. We have come up with the 4 ordinances, and after that these ordinances were repealed and they were replaced by the act in 1948. Okay, the right now whatever act which we are having, that is enacted in parliament in 1958. Okay, so that is known as the Armed Forces Assam and Manipur Special Power Act 1958, because at that point of time different states were not there, so Assam and Manipur Special Power Forces Act was there. Okay, that was 1958. After that there were various states which came into picture, and then act was known as the known in the current form, that is Armed Forces Special Power Act 1958. Okay, that is AFSPA. First it came into picture or came into effect in 1958. Okay, during the time of uprising by Nagas. Okay, now AFSPA gives an unfettered power. Now when it gives this unfettered power, it is given in section 3 of the act. Whenever a particular area is designated as disturbed area, okay, then these powers comes to the forces. That is unfettered power to armed forces and central armed police forces deployed in the disturbed areas to kill anyone acting in the contravention of law. They can kill anyone in the contravention of law. If there is a suspicion, then they can go for the killing. Okay, so that is a huge power which is there in the hands of the armed forces. So to kill anyone in the which is acting in the contravention of the law, arrest and search any premises without a warrant, and with protection from the prosecution against a legal suit. So basically when we are talking about the armed forces here, they can kill anyone, they can arrest anyone, and they can not be prosecuted without the permission of the government over here. Okay, so there is a legal immunity which has also been provided over here. Okay, the act was amended in 1972, and the powers to declare an area as disturbed was conferred concurrently upon the states as well. Okay, so now state and center, both of them can declare an area as the disturbed area under section 3 of the act, and then there will be these forces which can be deployed over there. Okay, Tripura revoked the act in 2015, Meghalaya revoked it in 2018. Okay, so here you can see there are these areas which are given wherein this act has been revoked. Let's see, one is your Meghalaya, second is your Tripura, from where this act has been revoked. Other than the other states like Assam, some parts of Assam, Arunachal Pradesh, some parts of Manipur, some parts of, you can say, Nagaland. These are the areas which are still having deployment of you can say imposition of the UPSPA. Okay, so this is about UPSPA which we have seen. Now we will be moving to the next part, that is basically your test, wherein we will be discussing few questions which you have to attempt and answer to me in the comment box. Okay, so let's see. Which article of the Indian Constitution deal with the protection of minorities? Article 15, Article 29 and 30, Article 19 and Article 21. Okay, then moving further, which article of the Indian Constitution provides for the appointment of Chief Justice of India? Article 124, Article 126, Article 129 and Article 130. Okay, then moving further, which article of the Indian Constitution has been interpreted to include accessibility for disabled person as part of right to life? Article 14, Article 19, Article 21 and Article 32. Such kind of questions has been asked in the UPSC earlier as well. When we are talking about the question which has been asked in UPSC, that is right to marry to a person of our own choice, that is a fundamental right under which article? So such question has been asked, so please keep a note on that. Now in the end we have this question: the term bulldozer justice primarily refers to a legal mechanism for swift property clearance, arbitrary demolition of the property as a punitive measure, compensation for property loss, and construction of new infrastructure in the public areas. Okay, so these are the questions which you have to attempt and answer to me in the comment box. With that, I would like to take your leave. I'll see you in the next episode. Till then, have a good day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.